It is no longer news that Peter Obi of the Labour Party is contesting the outcome of the 2023 presidential election in court. What is news, however, is the fact that one of the grounds on which Peter Obi and the Labour Party is contesting the results or the declaration of Tinubu as president-elect by INEC in the middle of the night like a thief is Tinubu's drug case in the US. Now, 6 months ago, Festus Keyamo went on Channels Television, live TV, and told 21 lies, blatant lies, to defend Tinubu then. And he got away with it because he was not called to order either by the NBA or by our judicial system. He got away with it. Now, this matter is now court case. Is Festus Keyamo ready to repeat these 21 lies to defend Tinubu in court? Because right now, what he did on Channels Television on Politics Today, when he was trying to talk down on Shehu Kimbalue, what he did was tell blatant lies. And it was not under oath, so he could get away with it. But when this case gets to court and the hearing starts, the tribunal is a court. If anybody lies in a tribunal, is lying under oath, and the person is committing a crime called perjury, for which the person could go to jail. Now the question is, these 21 lies that Festus Keyamo told to defend Tinubu about 4 months ago, will he repeat them at the tribunal, knowing fully well that he will be perjuring himself, knowing fully well that he will be lying under oath? Will he have the mind to repeat these 21 lies? By the way, if you have not seen the 21 lies that Festus Keyamo told on live TV to defend Tinubu on this US drug case, I'll play it for you now. Watch it here, and then you can decide for yourself if Festus Keyamo will actually be ready to lie under oath, to perjure himself, to go to jail to defend Tinubu. I wonder why this even is, because this is the same Festus Keyamo that was hunting and attacking Tinubu during Tinubu's first term in office and even second term. This was the same Festus Keyamo. What happened? That he switched to the opposite side and is now willing to tell lies to defend Tinubu. Now, telling the lies is on TV is one thing, but telling lies under oath in court, in a tribunal, means perjury and it means going to jail. Will Festus Keyamo be ready? And indeed, other lawyers in the APC team, will they be ready to tell lies to defend Tinubu and risk going to jail? Watch the 21 lies and then decide for yourself.
Those accounts were 10 accounts in 3 banks. Accounts legitimately opened by him, and there were funds that he kept saving, where he was keeping his savings in the US.
That's a lie, because his salary was $2,400, and at one point he deposited $661,000. At another time, he deposited $1.2 million. That's $1.8 million. How do you save $1.8 million when your salary on a monthly basis is $2,400, which is actually just $38,000 plus per year? And he stated it himself that he didn't have any other source of income. So where is the savings?
As I speak with you, if you want to know whether there is a criminal charge against somebody, you must have a complainant. So you will see the state versus so and so person. You must see that. And then you must have a charge number. You must have a charge number if there's a charge against anybody. There is no charge number in those documents.
There were 2 charges. That's another lie. 18 U.S.C. 1956 and 18 U.S.C. 1957, which borders on money laundering and financial fraud. And then there was a charge number. The charge number is staring you in the face, 93C4488. That's another lie from Festus Keyamo.
If you look at those documents too, Asiwaju Bola Tinubu was not mentioned as a defendant. They've skipped that. It was only account numbers that were mentioned, and at the end of the day, they just said account numbers in the name of Tinubu. That is all. Not that Tinubu was a defendant. It was accounts in his name. Not him. Those accounts were sealed, not him. It was action in rem.
That's another lie. The prayers of the United States Attorney was that due notice be given to all interested parties to appear and show cause why forfeiture should not be decreed. Who will come and appear? Is it the account number? So that's another lie.
There is no charge. There was no charge. There was no indictment. There was no criminal process. It was a purely civil process against those accounts.
There indeed were two charges, 18 U.S.C. 1956 and 18 U.S.C. 1957, which bordered on money laundering and engaging in money transactions in property derived from fraud.
Now, there was an affidavit by somebody called Kevin Moss. Kevin Moss is just a normal prosecutor you see.
That's another lie. Kevin Moss is not just another prosecutor you see. Kevin Moss is a senior special agent. And aside that, the work he did will boggle your mind. These 4 sections from the document outline that he filed 18,300 files. So that's no joke.
What they did in the case of Asiwaju Bola Ahmed Tinubu was therefore to file what they call an interim process for forfeiture. It was not a final process.
That's another lie. There were 5 documents, and the last of them is the final forfeiture, the final decree. You can see it there. So there was a final decree starting from the verified proof of forfeiture to the warrant of seizure, down to the settlement, down to the final forfeiture. So that's another lie.
The Kevin Moss, all those the positions you see there about narcotics and all that, it was not a judgment of the court. It was an opinion of a prosecutor trying to convince the court to issue a forfeiture order. It was not an opinion of a court.
Another lie. These are seizure warrants that were issued to first of all freeze the account, and then there was a final forfeiture that was issued, which is also an order of court. So to say it is speculative and it is not final, that's another lie.
And so it was a presumption. These processes are processes of mere presumption. So they found monies in his accounts. They said, well, they needed to come forward. And in that affidavit of Kevin Moss.
Again, another lie. This is verified complaint of forfeiture. They were not speculation. He backed it up with an affidavit and he got a warrant of seizure and then got settlement and got final forfeiture. So it is not mere speculation. This is another lie from Festus Keyamo.
They said they interviewed Mobile. Mobile said, yes, this man is a treasurer in the Mobile. But they said, no, those funds are not from them. But they confirmed his status, not as a criminal, but as a respectable employee of Mobile. It is in the affidavit of Kevin Moss.
This is a potential lie because the Mobile is talking about is Mobile Oil Nigeria Limited, which is not ExxonMobil, because many people seem to think that it is ExxonMobil. It is not ExxonMobil. In fact, the company has changed its name now from Mobile Oil Nigeria Limited to 11 PLC.
Look at paragraph 38 of the affidavit by Kevin Moss. I want everybody to look at paragraph 38. After the rigmarole of trying to find out whether the account in money, where the monies came from, whether they were linked to drug and all of that, it was all speculative. They came to the conclusion that the proceeds he got from the tax, the deposit he made there what they call what these bankers normally call investments. He kept the money there and he was getting profit on the interest. They said he had not paid tax on those interests. That is all. So it was not like a deliberate act.
That's another lie from Festus Keyamo. The whole charges that were brought against Bola Ahmed Tinubu were USE Code 1956 and 1957, and they bonded on money laundering. To say that it was tax is a deliberate lie. A very, very big lie. In fact, the forfeiture order did not include that it was for tax. This is the forfeiture order. The final order. It stated that it is for narcotics trafficking and money laundering. Those were the two charges. So this is another lie from Festus Keyamo.
Yes. Would you liken the settlement that Bola Tinubu had with the court in the United States at the time over these monies as a sort of a plea bargain?
No. A plea bargain, you cannot build something on nothing and expect it to stand. A plea bargain must arise out of a criminal charge. Like I said, there is no charge, nothing anywhere, nothing like a charge anywhere.
That's another lie from Festus Keyamo for Bola Ahmed Tinubu. There were two charges, USC Code 1956 and 1957, which bordered on money laundering and using proceeds illegally gotten. Going from that, you see now that there was a plea bargain. This is stipulation of compromise settlement, which is plea bargain. So there was a plea bargain, and in the plea bargain, initially it was supposed to be 1.8 million that was seized, but eventually they just fined him based on the charges that he was charged, because he was charged with two codes violation, USC Code 1956 and USC Code 1957. And if you look at the punishment for those violations, it says not more than 500,000 US dollars. That was why only 460,000 US dollars was deducted from the account, because that's what the law speculates as fine punishment for the violation of the law. The other option would have been imprisonment, which I'm sure that Tinubu would not have wanted. So there was a charge, there was a plea bargain, and there was a fine, which is actually the forfeiture of the 460,000 US dollar based on the law.
You established that there was a forfeiture, but if there was a forfeiture that was made, and that kind of forfeiture is still subsisting, and it has a criminal nature that has not been set aside up to date.
No. A forfeiture, you see, that's why I said you should take a paper and a biro. This is a lecture class for you. A forfeiture is not something hanging on your neck. It's a permanent settlement, and everybody will shake your hands and go your way.
The forfeiture in this case, which proves that this is another lie from Festus Keyamo for Bola Ahmed Tinubu, the forfeiture in this case is based on code violations for 1956 and 1957. The punishment for it is either fine of not more than 500,000 US dollars or imprisonment. And so Bola Ahmed Tinubu was given a fine, which is the forfeiture settlement that he got, and it was $460,000. There was a forfeiture, which is actually a fine based on the two charges that were brought against him.
I refer you again, paragraph 6, page 2 of the settlement signed. In that paragraph 6, they were even begging Asiwaju. They said that, look, please don't proceed against us again. This is a final settlement between us. Go your way, we go our way.
That's another lie from him, from Festus Keyamo. Festus Keyamo, as a senior advocate of Nigeria, knows that there is always indemnity clause in such plea bargains to prevent you from saying, or your children from saying, oh, the money that was seized from you was actually responsible for the death of your relative, and so they want to sue because of that. It's just an indemnity clause. That is usual. In fact, not only for plea bargains, that it's normal. So coming to say that they were begging him, that was just a blatant lie.
Out of the 10 accounts, it was only one account, the one in Heritage Bank, that they took $460,000 as their tax on his interest, as tax on interest, that he benefited from the deposits he made, that the investments he made in those accounts.
$460,000 was forfeited, and it was forfeited with respect to violations of USC Code 1956 and USC Code 1957. It's clearly stated here in black and white. It has nothing to do with tax. And if you go into details of what the punishment is for Code 1956 and 1957, you will see that it is a fine of not more than 500,000 or prison time. And so $460,000 is less than $500,000. That was the fine. That was the forfeiture punishment for Bola Tinubu for the violation of these two codes. So it's a punishment. The forfeiture was a fine that he actually paid. It's not tax. There was nowhere that it was stated that the 460,000 US dollars was for tax. And Keyamo knows this. So he blatantly lied to deceive Nigerian public just to protect and defend Bola Ahmed Tinubu. The NBA should sanction him for this action. This cannot be negligence. This is just blatant lie.
These documents, in fact, rather than indict Asiwaju, these documents exculpate him and makes him as white as snow.
This document actually nails Bola Ahmed Tinubu to the cross. It's a final nail on the coffin. It's clear. Look at it. It's a final order. It's a forfeiture. It said 460,000 US dollars belonging to Bola Ahmed Tinubu represents proceeds of narcotics trafficking or were involved in financial transactions in violation of USC Code 1956 and 1957. And the punishment of it is forfeiture. And the forfeiture is determined based on the fines or imprisonment that is the punishment stipulated for that law, for that charge. So this is another lie from Festus Keyamo for Bola Tinubu.
There's a fundamental question on the source of the money he deposited, of which he reached a settlement. Has he given a satisfactory explanation of the source of the funds?
Well, thank you so much. Now, at that point, the burden was on the prosecution in the US, or from the states in the US, to prove that the funds were proceeds of narcotics. Now, that is, if you look at paragraph, I want you to go to paragraph 2 of the affidavit of Kevin Moss. He kept saying that it was his reasonable suspicion. It was like probable cause, probable belief. It was speculative. Everything was speculative. They had not come to a definite conclusion.
That's another lie for Tinubu by Keyamo. They came to a definite conclusion, and that's why there was a forfeiture decree, a final one. And the charge there, you see it there, it is in violation of USC Code 1956 and 1957.
You go to a new land, you go to a new place abroad, any Nigerian you see, especially from your own tribe, they become like brothers to you. You associate with them, you visit them. You may do 1 or 2 transactions. You may not exactly know what they are involved in. You may not know what they are involved in. It happens to all of us. And you can see that the whole of that investigation actually touched on 2 or 3 Nigerians. So let me admit that had nothing to do with Asiwaju. And I don't want to mention their names here. People should go and read it, but because they have families in Nigeria. The other Nigerians, two of them, who were actually linked to narcotics. One of them was actually arrested. That one made confessional statements and confessed another Nigerian as the one involved. But that principal suspect, read that affidavit, never mentioned the name of Asiwaju. What happened? Asiwaju went to open an account. The address by which he opened the account was an address already, used by these people. I think some block of flats. Maybe he happened to be in that block of flats too. So they now linked it to say, oh, well, these other people they were investigating for narcotics, they are in the same address used by Asiwaju to open that account. So that is what is there. I cannot deviate from it.
That's another lie, because Bola Tinubu himself said he knew these people and he opened the account. The company he had access to had these people as shareholders. So that's another lie. Look at these documents.
Section 137 of the Constitution 1D, subsection 1D. Which says that a person under a sentence of imprisonment or fine for any offense involving dishonesty or fraud by whatever name it's called, or for any other offenses imposed on him by any court or tribunal shall not be qualified to contest for the office of the President of Nigeria. In view of the forfeiture and the settlement that Bola Tinubu had in the United States, as a senior advocate of Nigeria, what are the legal implications of that circumstance, considering the section 137, subsection 1D of the Constitution?
Well, forfeiture is not a fine. Fine is a punishment. Fine is a consequence of a conviction. Fine is a consequence of a criminal trial. So fine has nothing to do with forfeiture. Forfeiture is a civil process. It's a complete civil process to say, well, we are not even going into trial at all. The state goes into forfeiture proceedings with individuals just for the purpose of getting their monies.
2 charges were brought, USC Code 1956, USC Code 1957. And the punishment for those 2 violations is either a fine or imprisonment. And the fine specified for the USC Code 1956 is fine of not more than $500,000. So that's why he was fined $460,000, which he forfeited. This disqualifies Bola Ahmed Tinubu totally, because if you look at the fine that he paid, it's a fine. He paid the fine. He paid it. It's not disputing it. Though they call it forfeiture, the forfeiture here is a fine, which is the punishment for the violation of USC Code 1956 and 1957. So having been fined, it disqualifies Tinubu from running for the post of President of the Federal Republic of Nigeria. And of course, drug trafficking, money laundering is an offense. It's an offense. Engaging in monetary transaction in property derived from specified unlawful activity is an offense. So Bola Tinubu must be disqualified.
You have, at that point, he had not fulfilled his financial obligations regarding the deposits that were made there and the interest on those deposits. And so they said, well, you know what? Out of these 10 accounts, we are going to take our interest.
That's a blatant lie. Where do you see interest in the order here? This is the final order of forfeiture. It says that funds in so-so account to the amount of $460,000 in that account in Heritage Bank belonging to Tinubu represent proceeds of narcotics. Where did this say tax? And were involved in financial transactions in violation of USC 1956 and 1957, for which the punishment is a fine of not more than $500,000 or prison time. So which of these have to do with tax? That's another lie, another blatant lie from Festus Keyamo in defending Tinubu.
Forfeiture is that, look, this thing we think is our tax. Look at paragraph 38 now. They say it's tax. What belongs to them, they are just taking out, so you can go. They just took what belongs to them. So,
Paragraph 38 has nothing to do with the order of forfeiture. The order of forfeiture was for narcotics trafficking and money laundering. USC Code 1956 and 1957. So that's another lie from Keyamo, saying that it was for tax. It was not for tax. Paragraph 38 has nothing to do with the final forfeiture order. This is the final forfeiture order we're looking at here. The same document that Festus Keyamo has, which he said he has read over 10 years ago, and he's a son. I have read this for less than a week, and I can see and understand this in clear, simple English. This proves that Bola Tinubu stands disqualified. He stands disqualified. We must take this to court, and we will.
Tafa Balogun, at his level of the IG of police, now wrote an official letter to the United States, to the embassy in Lagos, to say, can you give us a response, the Nigerian government a response, as to whether Asiwaju was involved in any of such, issues. There was, therefore, sometime investigation. They contacted the FBI in the United States. And then the FBI, supplied the information to the embassy in Lagos. And then the Michael Bonnet wrote back to the Inspector General of Police, Tafa Balogun, and said, look, we have official confirmation from the United States that there was no criminal indictment, no conviction, no criminal charge against Asiwaju Bola Ahmed Tinubu.
Now, that's another lie, because this is the letter that you are looking at in front of you. What it says is that they have checked their FBI database and there is no arrest record, no criminal arrest record, no warrant, no warrant for Tinubu's arrest. That was what he said. He did not clear Tinubu of any criminal wrongdoing. He just said that there was no criminal arrest. And of course, nobody is saying that there was a criminal arrest because there was a plea bargain. He was even here in Nigeria when all these activities were going on. So he couldn't have been arrested from Nigeria. He was fined based on the laws that he violated, the USC Code 1956 and 1957. So using this letter to say he was cleared, that is a lie.